Um, I think we will begin. Thank you all for joining in today. I'm going to put everything in presentation mode to mute any background noise. And what I will do after I run through things is unmute so that we can handle any questions. So if you've got questions, please save them to the end. Thank you.
The conference is now in silent mode.
So thank you again for joining in today. What we're going to cover is the additional estate planning features that came out with the last release. And I thought I'd start first of all by just reviewing the enhancements for what I will call seniors. So you can see in this plan, I've modeled Bill Sr., his wife, Mary, and if we look at the family tree, I've connected them as parents to Bill. If we go to entries and look at Bill Sr., what you see now is the ability to model homes, and in fact, all conventional entries, whether it's vacations, vehicles, portfolios, the different types of retirement plans. Notice, of course, that RSPs and DCPs are disabled because of Bill's age. So it's the ability then to add all of these entries that allows us then to create assets for seniors, and then from there to be able to model the terms of their wills. So if we go back to the About page, just a couple of things that I want to point out. When you add an other party who is a parent and other related, the first party that you add, this button is disabled. However, when you add a second party, it becomes enabled. And what that button does is it allows you to connect Bill Sr. and Mary as spouses or common law partners, or in fact same-sex couples. So you can define their relationship. And then, of course, if we select spouse or common law partner, then what will happen on Bill's death is that there'll be a tax-free rollover of his assets to his spouse or common law partner, Mary. So if we go down to entries, what I've done is I've added a cottage. Now, I want you to notice that this is on Bill Sr.'s tab. So it's actually a cottage that's owned jointly by Bill Sr. and Mary, but we didn't include a joint tab for parents. However, that doesn't reduce any functionality. So even though I've added it on Bill Sr.'s tab, could have been Mary's tab. As you can see, I can still create them as joint owners. And you'll notice in this case, they're individual tenants in common. Of course, they could be joint tenant with right of survivorship, probably the more likely case. If we go down to wills, then you'll see that we have the full functionality now to dispose of that asset via the will. And what you'll see I've done in this particular case is that Mary is, of course, Bill Sr.'s beneficiary, but I've set up the contingent beneficiary as Bill, their child. I could have included Bill and Sue if I wished. For Mary, her beneficiary for her half of the home is Bill Sr. And again, her contingent beneficiary is Bill. And then if we look at Bill, his beneficiary is Sue. The contingent beneficiary, should be Bill Jr. And then for Sue, the beneficiary is Bill Jr. So when Bill Sr. or Mary dies, whomever dies first, the cottage will go to the other party, And then on the death of the second of the two, it will go to Bill. And then from Bill, it will go to Bill Jr. Or sorry, it will go to Sue. And then from Sue, it will eventually go to Bill Jr. So let's go back to entries, and we'll have a look at how all of this flows from the point of view of taxes. Just take a moment to load this. So if we go to entries, we see the cottage. We see the cottage on Bill Senior's tab, and we see the cottage showing up as an asset for him. And I made the cottage, by the way, $1 million. So if we look at Mary's tab, then she owns 50% of the cottage. What happens, of course, if we go to net cash flow and we look at Bill Senior, no appreciable taxes in his year of death, just taxes on any income that he's drawing. But if we, because the cottage, of course, is rolling tax-free to Mary, but if we look at Mary's taxes in her year of death, we see that there'll be a capital gains tax on the cottage, which is now being left to Bill. And we can see this if we go to the estate output. Bill Senior, again, not much in the way of taxes. His assets are going to Mary. But when we go to Mary's tab, we'll see that her assets are going to Bill. So all of this flows like it normally does for a will. So we can see the assets named in the will and so on. But the important thing also is to have a look at what the implications are from an estate point of view. She will have RIF money that will be, going into her estate. And so there are substantial taxes at death given both the RIF assets that will be left to Bill and also the cottage. So let's go back to entries. And once again, I'll just show you the cottage. We can see the cost base, the current value. But if we now go to Bill's tab, what you'll see is a linked cottage. So this is passing from one generation to the next. And if we have a look at it, you can see that the cost base for him is adjusted up to the $1,800,000 value in 2027 when he receives the cottage. And then, excuse me, again, if we go to the estate tab and we look at Bill's estate, we see that he's leaving the cottage to Sue. It's rolling over tax-free, but obviously the issue will arise on Sue's death when the cottage then passes from her to Bill Jr. So we can see that now where Bill Jr. is getting all of the assets, the residue for distribution is quite negative. And if we look at Sue's taxes in the year of her death, then we can see the substantial capital gain that's going to occur on the cottage when it's passed ultimately from Bill to Sue to Bill Jr. So I'm going to unmute now and entertain any questions.
The conference is now in talk mode.
The conference is now in conversation mode. All participants are now unmuted.
Anyone with any questions? So the intention of all of this clearly is that as the population ages, especially the baby boomer generation, our view is that the will I be okay in retirement question is, of course, very important to them, but equally important if you're dealing with mass affluent or higher net worth clients, we believe that the estate questions are also of importance to them. And the only way that you can really understand estate issues, of course, is to incorporate the terms of wills into the financial forecast. So we wanted to expand that to include multiple generations. So now we can do aging seniors, their children, and in turn, their children. So it's the 3 generations.
Michael?
Yes.
Oh, hi, it's Alexandra. I just have a quick question.
Yes, Alexandra.
I understand how or when this particular file is being built. Is the client Bill Jr. and Sue, or is the client you, Bill, and
So, yeah, the client would be Bill and Sue with their child, Bill Jr. That would be your normal client in most cases. But what I've done is I've added Bill Sr., the parents. And you can see, for instance, that if we go to Bill Sr., he's actually 82 right now. And Mary is 76. So the parents of Bill's parents, as we saw from the family tree.
scenario, we're not trying to solve for Mary's eventual tax obligation. It's just to say if it continues like this, the plan would conceivably have this major tax issue while you're benefiting or receiving the cottage as an asset. So there's a liability for your aging parent. But ultimately, if that's how it played out, then this is what your future would look like with the cottage.
Yeah, I think we need to say Bill and Sue in this particular case. We've got your aging parents. They happen to own the cottage, and they're intending to pass it to you, which may or may not represent a substantial capital gain, depending on the ACB of the cottage. I mean, if you're a senior and you own a cottage, you may well have owned it for decades and have a very low ACB. The difference between the value of the cottage today and the value at life expectancy for Bill Sr. and Mary, that difference may not be that great. But again, if the cottage has been owned for a long time, there's could be a very substantial capital gain. But the point is that if Bill Sr. dies, his half goes to Mary. Mary then leaves the cottage to Bill, and Bill wants to keep it in the family and have it ultimately go to Bill Jr. Now we could be talking many, many years into the future with all that growth building up. So essentially what we're able to do now is we're able to go to the estate tab, understand the tax liability when Mary, the parent, passes away and leaves the cottage to Bill. And it could well be that if they own a home and they have remaining RIF assets and so on, that, you know, the liquidity in Mary's estate ultimately may be more or less sufficient to handle the tax problem. But, you know, when that cottage in turn passes from ultimately Sue to Bill Jr., because we're talking many years into the future, then we could have a really huge problem. So we can see here that Mary's liquid assets would be $551,000, taxes $708. So we'd have a deficiency of about $200,000. So now we understand if they pass the cottage to you, you know, there's going to be this kind of tax bill. Now, again, depending on age and so on, is insurance a viable option when the first generation passes away? So I've made Bill Sr. and Mary 82 and 76, but you may be dealing with the boomer generation that might be in its late 60s, early 70s, and that would be G1. And then Bill Jr. would be G2, and then, you know, his children G3. So it's possible that first generation could still put insurance in place. That's really what we're driving at. And then, yeah. And then certainly Sue,
But of course, solving for here.
yeah.
And it's not the seniors, it's
Well, we could be solving for 2 generations on the insurance need, depending on age. Okay, I mean, if Mary were insurable at her age of 76, then we might be able to put insurance in place for Mary.
absolutely. Yeah, I just wanted to know, understand the extent, like, sort of what drives building the multi-gener, like, the ideal scenario. So it's, you have your clients and you have your parents, and you just want to get it, if you know what your inheritance could be from the older parent generation, then let's see what their liability is and
Yes.
do a quick assessment of that while
Yes.
solving for.
Yeah.
Okay, I just wanted to get clear on that.
Well, and part of all of this, of course, Alexandra, is that what we're really trying to do is help clients see beforehand what the issues might be. So whether insurance is a solution or not a solution, what we're now able to do is say if the parents own the cottage, and, it's passing to Bill and Sue, then be prepared. There's going to be a liquidity problem of close to $200,000 in the estate. And if insurance isn't a viable option, maybe we need to do something that intentionally to try and increase Bill and Sue's liquidity in this case, over the next 10 years in order for them to be able to pay the tax on the cottage.
Right.
Right?
Yep, that makes sense.
Okay. So it's just, getting that fuller picture developed for people if this is the case. And I use the cottage, of course, because I think it's a very common situation where cottages may have been in families at this stage now, what will in effect be 3 generations. And possibly even a 4th generation now, but at least the 3. And, the people have a great attachment to their cottages. They don't make any more waterfront property, and people, want to keep the cottage in the family and have really no concept of what that's going to mean, over the G2, G3 transfers. Anybody else with any questions? So we'll post a video of this so that you can go back on our YouTube channel so that you can go back and replay it at any time. And again, I think it's a question when you're dealing with your clients, Bill and Sue, you have the ability now, if you wish, to work in their parents as parties to the plan. And their financial circumstances, RIFs, homes, cottages, everything else, to really be able to develop that much fuller picture for your clients. So if there are no more questions, I'll thank you all for your time, and I wish you a great weekend.
Thanks, Michael.